Good afternoon. This is Judge Alyssa Perez resuming the criminal docket of the 210th District Court for January 11th, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. I am our bailiff today, so I'm going to go ahead and call our first plea cases from the jail, calling cause numbers 2020-D04469 and 2019-0D03148. May I have announcements, please?
Robert King, Texas.
Yes, Edward Hernandez on behalf of Jesus Alberto Torres, we're ready to proceed, Your Honor.
Mr. Hernandez, do you see your client appearing from the jail annex?
I do, Your Honor.
Okay, Mr. Torres, I'm going to be asking you some questions, so I need to swear you in. Would you please raise your right hand?
Yeah.
As best as you can, sir. Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes.
Thank you very much. You can put your hand down. Sir, would you state your name for the record? Mr. Torres.
Oh, Jesus Alberto Torres.
Sir, I'm going to be asking you about documents you may have reviewed with your attorney. We're here for pleas on two separate cases. The documents I'm going to be asking you about, generally, there's going to be one set of documents per case. First set of documents I'm asking you about are marked as States Exhibit number 1. Those are the plea papers for each of these cases. Within those documents, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Torres, do you recall reviewing States Exhibit number 1, the plea papers for each of these cases with your attorney?
Yes.
Did you understand everything contained within those documents?
Yes.
Mr. Hernandez, have you had more than 10 days to prepare defenses in each of these cases?
I have, Your Honor.
And do you believe, did you explain the plea papers to your client?
I did, Your Honor.
You believe he has understood the admonishments, rights, and consequences of giving up these rights by entering pleas today?
I do, Your Honor.
Mr. Torres, are you satisfied with your attorney's representation of you?
Yes.
Mr. Hernandez, do you have any reason to believe your client is not presently competent to enter pleas?
For the record, Your Honor, my client was previously not competent, was sent to Vernon, was restored to competency, and we subsequently reached an agreement with the state after he was restored to competency. I believe at this time that he is competent, Your Honor.
At every point when you have been, since he was restored to competency, have you had any concerns regarding his ability to understand your conversations and the implications of his pleas today?
No, Your Honor, no concerns.
Okay. Mr. Torres, as your attorney mentioned, there was a previous competency evaluation. As we stand right now, do you have either any diagnosed condition or any other mental health condition that is preventing you from understanding what we're doing today?
No.
You were able to communicate with Mr. Hernandez regarding your plea today and your cases?
Yeah.
Okay. So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Mr. Torres, are you a U.S. citizen?
Yes.
Where were you born?
El Paso?
In El Paso, Texas?
Yeah.
Okay. Okay, so as to cause number 2020-0D04469, although originally indicted as a first-degree felony, my understanding is your plea is going to be to a lesser included offense of arson, reckless damage to a building, causing bodily injury or death. That is a state jail felony. To that charge, sir, what is the lesser included charge? What is your plea, guilty or not guilty?
Guilty.
And in cause number 2019-0D03148, I believe they are being pled to as charged. It is count 1, aggravated robbery. To that charge, what is your plea, guilty or not guilty?
Guilty.
And as to count 2, same charge, aggravated robbery. What is your plea, guilty or not guilty?
Guilty.
Are you making each of these pleas freely and voluntarily?
Yes.
I will find you are making your pleas voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element of each count. Count 1, aggravated robbery. Count 2 as aggravated robbery beyond a reasonable beyond a reasonable doubt. I apologize. At this time, the state moves to admit Exhibit 1 as the state's plea papers, Exhibit 2, Article 3914 disclosure, and Exhibit 3 as the indictment. And this is to run concurrent with cause number 2020-0D04469.
And any objection?
Your Honor, no objection, but a clarification, Your Honor.
Mhm.
With regard to 2019-0D03148, if the court would notice in the plea papers, we did do a little bit of editing, and I just wanted to explain for the record what that editing is. Although my client is pleading to robbery at this time, and he's currently serving a TDC sentence, the actual occurrence of the robbery was prior to his plea on the case he is currently serving on. And because of that, his sentence, if it had occurred after the other sentence, if it had occurred after 2018 0D05013 and 2019 0D00341, then it would have run consequent to those cases. But because the incident actually occurred before, the law allows them to all run concurrent. And that's what the modification was, Your Honor. This isn't as opposed to the state jail charge of the arson, which did occur afterwards. By law, it has to run consecutively, and it does not start until his 4-year current sentence at TDC on those other 2 cases ends. But his robbery case, because even though he's pleading to it afterwards, because it occurred before, it runs concurrent with the 2018 and 2019 charges that I just read into the record, Your Honor. Because the date of arrest for this case, 2019 0D03148, was before the plea. It is not subject to the requirement that it run consecutive to the current case he's already doing time.
Okay, understood. And then that's only as to the ag robberies, correct?
Yes, Your Honor. So the ag robberies would run concurrent with the sentence he's already serving in 2018 0D05013 and 2019 0D00341, and it'll also keep running concurrent with the state jail. In other words, the state jail doesn't have to wait till this one ends either, because he's pleading to them at the same time. It's only the state jail that has to run subsequent to the current sentence he's already serving on the 2018 and 2019 charges, Your Honor.
Okay, give me 1 second. Understood. Okay.
I just wanted to get it on the record so when TDC sees this.
Right. And I think that, Marissa, that's exactly what you were messaging me about, correct? So we're looking back to the credit that, let me see. He was booked, where is it? I think he has 972 days on 3148. So
Yes,
it will run. And what you've notated in the plea papers, Mr. Hernandez, is simply that it run concurrent and not, I guess, consecutive to the case for which he is on probation because the date of offense precedes that, correct?
All right, he's not on probation. He's actually doing the TDC sentence.
Right, doing the TDC time, correct. He's not on probation.
That's correct, Your Honor, because he was arrested in May of 2019 on the ag robbery, and in June of 2019 he pleaded to the other cases. So those all run concurrent because he was arrested on all of them at the same time.
Okay, got it.
Thank you.
Okay, understood. Now, I think it goes now. So, where were we? We were at the plea agreement. Was all of those notations, Mr. Hernandez, is that your understanding of the plea agreement?
Yes, Your Honor.
Okay.
And that part of the plea agreement is on the state jail on the 2020 0D04469. So there's a mandatory subsequent, in other words, that sentence won't start until he finishes the 4-year sentence that he's already serving on the 2018 and 2019 cases.
Okay, and so I don't think we had gotten there, Ms. King, with respect to the state jail felony, the 2020 case. What is the plea agreement?
Your Honor, it was going to be the state jail felony for 2 years, I believe.
2 years.
Yes.
Okay. All righty. Mr. Hernandez, that's your understanding of the plea agreement as to that case?
That's correct, Your Honor.
Okay. And Mr. Torres, is that your understanding as well?
Yeah.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next documents I'm going to ask you about, it's one per case, is the one-page trial court certification of your right to appeal. It is a document that explains your appeal rights. Because these are plea bargained or negotiated cases, you do not have automatic rights of appeal. Mr. Torres, do you recall reviewing and signing the trial court certification?
Yes.
It was signed by your attorney and signed by me as well. So on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiate your guilt. In cause number 2020-0D04469, I will find you guilty of the lesser included offense of arson, reckless damage to a building, reckless causing bodily injury or death, the state jail felony, and I will sentence you according to the plea agreement to 2 years confinement in the Texas Department of Criminal Justice State Jail Facility. In cause number 2019-0D03148, I will find you guilty of 2 counts, and counts 1 and 2 of aggravated robbery, and sentence you again according to the plea agreement at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. That latter sentence will run concurrent with your sentences in cause numbers 2018-0D05013 and 2019-0D00341. You will receive, as to all of these, credit for time served. Is there anything further, Mr. Hernandez or Ms. King?
Nothing further from the state, Your Honor.
I believe nothing further, Your Honor. I believe that's it. Ms. King, nice to meet you. I don't think we've met before. Okay.
She's our
Sorry,
new prosecutor. We're very excited.
Nice to meet you, Mr. Hernandez.
Be safe, Mr. Hernandez. Thank you.
Thank you, Your Honor. Thank you.
Annex, do we have all of our defense attorneys here? Chris, have we let everybody in?
I'm here, Your Honor.
Hey, Julia.
I have Mr. Luis Manuel Estrada,
Okay.
and he has been in for 276 days, and it is a plea to probation. We had sent the paperwork twice on November the 5th and again on December the 9th.
Okay, I have that one down. Annex, if we could get Mr. Estrada, I have it down as 8 deferred. Is that right?
Yes, Your Honor.
Okay.
And
Your Honor,
I
my
believe-
excuse.
I
Yes,
believe-
Mr. Hernandez, be safe. Go do
Thank
what
you,
you
Your
got.
Honor.
I believe
Mande.
part of the confusion was that one of the counts was supposed to be dismissed, and ADA Herrera used to send the dismissal after the plea was done. So I'm just kind of giving you some background.
Sure, I have it down for 8 deferred, counts 1 and 3, and dismissal of count 2. Is that right?
Yes, Your Honor, it is.
Okay.
That's correct, Judge.
All right, let's go ahead and get started calling cause number 2021-0D01176, State of Texas versus Luis Manuel Estrada. May I have announcements, please?
Roa King for the state of Texas.
William Martin on behalf of Mr. Estrada, ready to proceed, Your Honor.
And do you see your client appearing from the jail annex?
Yes, Your Honor, I do.
Okay, Mr. Estrada, this is Judge Perez. Can you hear me okay?
Yes, ma'am.
Okay, perfect. If you'll keep your own volume up, I'm going to be asking you some questions, so I need to swear you in, please. You raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Would you state your full name for the record?
Luis Manuel Estrada.
Okay, Mr. Estrada, as I mentioned, I'm going to be asking you about documents you may have reviewed with your attorney. The first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Estrada, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, ma'am.
Did you read and understand everything contained within that document?
Yes, ma'am.
Ms. Martin, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor, I have.
And did you explain the plea papers to your client?
Yes, Your Honor, I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
Yes, Your Honor, he does.
Mr. Estrada, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Ms. Martin, do you have any reason to believe your client is not presently competent to enter a plea?
Your Honor, he's competent.
Mr. Estrada, I'm sorry?
I didn't hear you towards the end, Your Honor, just letting you
Oh,
know.
okay. Sorry about that. I'll try and slow down.
Thank you,
Mr.
Your Honor.
Estrada, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Raleigh, California.
In California?
Yes, ma'am.
Okay, so in this case, you are charged, I understand the plea is only as to counts 1 and 3. So count 1 is assault of a pregnant person. To that charge, sir, what is your plea? Guilty or not guilty?
Guilty.
As to count 3, the charge is assault, family violence, impeding breath or circulation. To that charge, sir, what is your plea? Guilty or not guilty?
Guilty.
Are you making each of your pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas freely and voluntarily. Mr. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element of each count. Count 1, assault of pregnant person, and count 3, assault, family violence, impeding breath or circulation beyond a reasonable doubt. Direct in this case is the state to dismiss count 2, assault of a pregnant person. At this time, the state moves to admit exhibit 1 as the state plea papers, exhibit 2 as Article 3914 disclosure, and exhibit 3, the indictment.
Any objection, Ms. Martin?
No objection, Your Honor.
Without objection, states exhibits 1, 2, and 3 are admitted. What is the plea agreement?
Your Honor, it's going to be 8 years deferred, $4,000 fine to probate, $3,500, 200 hours of community service, and no offensive contact with victim. And the name of the victim is Scarlett Velasquez, with the remaining terms and conditions stated on the plea paperwork.
And then a dismissal of count 2 as well?
That is correct, Judge.
Okay, Ms. Martin, is that your understanding of the plea agreement?
Yes, Your Honor, it is.
Mr. Estrada, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page certification of your right to appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Estrada, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
It was signed by your attorney and signed by me as well. Finally, the last document I'm going to ask you about is the motion for deferred adjudication. Mr. Estrada, do you recall reviewing and signing the motion for deferred adjudication?
Yes, ma'am.
Ms. Martin, have you explained to your client both the benefits and detriments of deferred adjudication?
Yes, Your Honor, I have, and I've also explained to him that he is pleading to offenses that, as the law stands today, do not allow for a certificate of non-disclosure. And having told him that, he told me he wished to proceed with the plea.
Is that accurate, Mr. Estrada?
Yes, ma'am.
Okay, do you understand also that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment for these offenses? Do you understand that?
Yes, ma'am.
Are you asking the court to grant you deferred adjudication?
Yes, ma'am.
I will find there is sufficient evidence to substantiate a finding of guilt. However, I will not enter a finding of guilt at this time. Instead, I will defer further proceedings and place you on community supervision pursuant to the plea agreement for a period of 8 years. There will be a $4,000 fine, $3,500 of that is probated, 200 hours of community service, anger management, curfew, no offensive contact with the complainant. You are to attend BIP class, subject to urine and breath analysis, screen for TAP. There is also a family violence finding. And once I receive it, I will sign the dismissal as to count 2. Is there anything further, Ms. Martin or Ms. King?
Nothing further.
Nothing further, Your Honor. You have it, Mr. Estrada. Thank you.
Thank you very much. Good luck to you, Mr. Estrada. All right, I think we have, let me see, Miss Ramsey. I don't know if she's at the downtown jail or if she's at the annex.
I think she's annexed.
Oh, are you there, Avalar? Okay, cool.
Yes, ma'am.
All right.
Or whenever you're ready. Yeah, that's her.
All right. Miss Ramsey, how are you?
I'm good, ma'am. Thank you.
Okay, if at some point you can't hear us, let me know, okay?
Yes,
We're gonna
ma'am.
go ahead and get started with, we're set for a plea of true, calling cause number 2020-0D04156, State of Texas versus Sylvia Cecilia Ramsey. May I have announcements, please?
Roa King for the state of Texas.
And Daniel Avalar for Sylvia Ramsey. Good afternoon, Judge.
Good afternoon, Mr. Avalar. Do you see your client appearing from the jail annex?
Yes, ma'am.
Okay, ma'am, I'm going to be asking you questions, so I need to swear you in. If you would please raise your right hand. Ma'am, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Okay. Now you can lower your hand and please state your name for the record.
Sylvia Cecilia Ramsey.
Ms. Ramsey, are you the same individual who on September 7, 2021 entered a plea of guilty for the offense of driving while intoxicated, third or more offense? I believe you were given 4 years community supervision. Are you that same individual?
Yes, Your Honor.
And Mr. Avalar, do you waive formal reading of the motion to revoke?
Yes, Your Honor.
Okay, Ms. Ramsey, there were documents associated with your plea today marked as States Exhibits 1, 2, and 3. Do you recall reviewing those with your attorney and signing those documents?
Yes, Your Honor.
Did you read them and understand everything contained in there?
Yes, Your Honor.
And are you freely and voluntarily waiving the rights explained in those documents?
Yes, Your Honor.
You understand that by signing, you are giving up certain constitutional rights? Do you understand that?
Yes, Your Honor.
And that you are making a judicial confession. Do you understand that?
Yes, Your Honor, I do.
Do you understand that on your plea of true and all reasonable probability, I will find the allegations in the state's motion to be true, and in all reasonable probability, your community supervision will be revoked? Do you understand that?
Yes, Your Honor.
With regard to the motion to revoke, do you wish to enter a plea of true or not true?
True.
Other than any plea agreement reached between you and the state, are you pleading true because the allegations are true and for no other reason?
Yes, Your Honor.
Okay. And I understand the plea agreement was for 2 years TDC, is that right?
That is correct, Judge.
Yes,
Mr.
ma'am.
Avalar? Okay.
Yes, ma'am.
And Ms. Ramsey, that was your understanding as well?
Yes, Your Honor.
Okay, at this time, I will accept that plea agreement. Ms. King, are you offering up states 1, 2, and 3?
Yes, Your Honor, I am.
Okay, states 1, 2, and 3 will be admitted. The court will take judicial notice of all documents in the district clerk's file under this cause number. Ms. Ramsey, based on the evidence presented here today and on your plea of true, I find there is sufficient evidence to support the allegations in the state's motion, and I will now make a finding that the allegations are true. The judgment under this cause number is hereby amended from 5 years community supervision to 2 years confinement in the Texas Department of Criminal Justice Institutional Division. You will receive credit for any and all time that you have served. Okay, is there anything further, Ms. King or Mr. Avelar?
And further from the state, Your Honor.
Nothing from the defense.
Thank you very much, Ms. Ramsey. Good luck to you.
Thank you, Your Honor.
Okay, let's see if we have another plea. I thought we might have one.
I'll stand by, Your Honor.
You have someone else, Mr. Avelar?
It's a bond hearing. Whenever the court's ready.
Okay, well, who is it? Let's take care of yours. I apologize,
it's-
everybody. I'm bailiff. So let's take care of Mr. Avelar's bond.
It's Isaac Prado, and you know what, Judge? The probation department might be involved because he's on probation.
Okay, Carlos
So-
should be here.
Okay.
Annex or, oh no, downtown has them. Okay, give me 1 second so I can pull up the case. All right, calling cause number 2016-0D02484, State of Texas versus Isaac Nathaniel Prado. May I have an announcement?
Roa King for the state of Texas.
And Daniel Avalar for Isaac Prado.
And Mr. Prado is appearing from the downtown jail. Is that your client, Mr. Avalar?
Yes, Your Honor.
Okay, give me 1 second. I'm trying to look for Carlos somewhere.
Yes, ma'am.
There we go. Okay, we're set for a bond hearing today. Mr. Avalar, you may proceed.
Thanks, Judge. And I think there's two primary issues, I think, and Ms. Pineda can expound on this, but one issue, and I know it's important for the court, is restitution. I think the total amount was in the range of $11,000, to which half has been paid. His probation ends, I think, later on this year in the fall.
Mhm.
So I think it looks like he might run a little tight unless he can come up with something between now and September. The second thing, Judge, is I'm hearing grumblings of Mr. Bravo not reporting. And so I think he's been in custody since early December, if I'm not mistaken. And so, of course, there's a probation case. I don't even think there's a bond. So we are asking that the court allow him to be released so that he can get back on that restitution track and make the victims whole.
So let me ask real quick, Carla, when it's showing $12,000, almost $13,000 in restitution. There has been payments a little over $1,200. When were those payments? Were they recent or were they back in like 2017 when he was actually reporting?
Let me pull that up.
Oh, and you know what, Judge? Okay, I'm sorry to interrupt. You gave an amount. It's my understanding, and Mr. Paulo can verify. We talked to Mom, and we understand that $6,500 has been paid. It was paid yesterday.
Do your records reflect that, Ms. Pineda?
Yes, Your Honor. So initially there were one payment back in 2017, 3 payments in 2019, and then today's payment of $6,500, which leaves the new balance of $5,232.
Is he working, Mr. Avelar?
Judge, he is. It looks like he works for a food truck called, I think it's El Güero, something like that.
So clearly the issue is your client just decides not to report for significant amounts of time. That's the problem, Mr. Prado.
Yes, ma'am.
I have no assurance that you're going to report because you've never really reported consistently. What are we going to do, Mr. Avelar? I mean,
I agree with the court. I think the easiest thing to do is just kind of show up or make a phone call.
I mean, who's really making the payments? Is Mom making the payments? Because if he can sit in jail and Mom is just going to fork out all that restitution, I mean, because I can't give him a bond that isn't going to put him further in the hole, right?
Yes, ma'am. I know who physically played in that. That's Mom, but I don't know whose account it came from. The only thing I can argue, Judge, is he's been in custody for some time, and a payment has been made.
So are you telling me if I keep him there longer, more payments are coming? What are you telling me?
Right. No, I'm asking that he be released, and maybe I would offer an extension of a year in return.
Your Honor, if I may, the state did file an MTA this morning. We should have been done by this case by this time. So
Let me ask, has anyone spoken with, who's our victim on the restitution? Has any either probation or anybody had, I don't imagine, Ms. King, you guys would, but if you do, let me know.
I believe it's Dick Poe.
I don't see any documentation, Judge, where there's been communication from probation.
Okay. All righty. So he is entitled to a bond.
Yes, ma'am.
His bond is going to be $75,000. It's going to be $75,000. We're going to do a review in 30 days, Mr. Avelar. Carla, somebody needs to make contact. I'm not sure if DAs would be easier or probation. Somebody needs to make contact and see where we are with the complainant on the restitution. What was it outstanding for? What was it, a vehicle or what was it?
Let me check. What is it there?
Your Honor, I believe it was for damaged windows and a door damaged for a vehicle from Dick Poe dealership.
You might want to look, you might want to look at that restitution, Mr. Avelar. We need to kind of see where we are with that. For now, that's going to be the bond, okay?
And Judge, that's cash or surety, right?
Correct.
Yes, ma'am.
We're going to come back in 30 days. I'm going to put it at the 3 p.m. setting. I'm thinking he's not going to bond out, but I'm not so sure. For now, we're going to leave it at the 3 p.m. setting in 30 days. You have your bond. Let's see what we can work on. Maybe if you all can look at that restitution, maybe ultimately certain things are satisfied.
Well, the
Okay?
new amount is over the new balance. I'm sorry. The new bond is over the balance of what he owes.
Right.
So I would suggest that if he does have it, and I don't know that he does, that if he does come up with it, I'm assuming Ms. King, or I would hope Ms. King would just dismiss the MTA and let him continue on probation.
So I guess that's what we'll see in 30 days, if there is some way to make that victim whole or some other resolution. Okay.
Yes, ma'am. Yes, ma'am.
All righty. Thank you very much.
Thank you. Appreciate it.
Thank you. Okay. Let's see. Okay, so is downtown done? Downtown, did they leave? Yeah, I think they did. Okay, let's go back to the annex. And I see Mr. Roman. Let's go ahead and take care of his client annex. And again, I apologize, everyone. I'm not a good bailiff.
And no problem, Your Honor.
Just kind of going with what I see. And then if someone will remind me, we'll go to Carrillo next. That'll be Mr. Nunez. And at least that way, at least I'll follow some order on the docket. Being a bailiff is hard.
Mr. Carrillo, next defendant, Your Honor.
Which defendant is it, Judge?
Oh, I didn't hear. Oh, we're talking about Mr. Monades. Mr. Monades. Sorry, annex. I'm a little rusty starting 2022.
You're not alone, Judge.
I try and go in autopilot and then I say incorrect words. That's okay. Is that Mr. Monades?
Yes.
Okay. Alrighty, let's go ahead and get started. Calling cause numbers 2021 0D03075 and 2016 0D02790. State of Texas versus Francisco Monades. May I have announcements?
Roa King for the state of Texas.
Good afternoon, Your Honor. Richard Roman on behalf of the defendant Francisco Monades.
And Mr. Monades is appearing from the jail annex. We're scheduled for a bond hearing today. I just see it notated on the probation case, Mr. Roman. What are his bonds? I'm imagining, was it a no bond or does he have a bond on the?
Yeah, there's a no bond and a KPS, Judge.
On the 2016 case?
On 2016, 2790, yes.
Okay, and the bond on 3075, how much is that?
It's 21,000.
Okay. And here's my next question. Is that my bond or is it a jail magistrate bond? I was looking it up, but then we got busy, so I
believe it's a J.
It's
For
a
that one,
JMAG
it's a
bond?
JMAG, yes, Judge.
Okay, so that's a JMAG bond. Okay. All righty, Mr. Roman, you may proceed on the bond hearing.
Yes, ma'am, Your Honor. My client's been incarcerated now about 76 days. He's 43 years old, graduated Montwood High School. He's got 1 year community college. He's got a degree from Kaplan College as an import-export clerk. If he were to receive a bond, his job there is still secured and he would return back to that job immediately. If released, he's going to be living with his father where he was living before at 12607 Guerra Norte, 79938. Incidentally, this residence, which is the father's name, is the security for the bond. So we think there's more than ample amount there to ensure his return to court. Nevertheless, he's never absconded. He's performed and almost completed his community service until he had this hiccup. We understand the gravity of the present pending claim. We're prepared to on the arraignment documents for the newly indicted claim, Your Honor, but he's accepted responsibility. He's known he made a big mistake. He's actually taken great strides while incarcerated, taking addiction classes, and there's some information I've provided to the court in that regard. So we'd ask the court to entertain a reasonable bond for him today so that he can get on his path. And we've got an idea of how we'd like to present a disposition to the DA's office on the pending case and the pending probation matter.
Hey, Ms. King, go ahead. And just so you know, Mr. Roman, I did see that. I think it was maybe over the holiday break. There was a letter from some type of treatment provider. I did review that, just so you know.
Yes, thank you.
Go ahead, Ms. King.
Your Honor, the state would object to the granting a bond or lowering the bond because this is technically his fourth DWI. The BAC in the recent case was 0.189. And he pretty much, there is a DWI conviction every 2 years. I'm not sure, for community safety that it's safe for him to be out.
Your Honor, the value of the bond, the value of the house is in excess of $125,000. It's in the father's name. It's his house. We think that's plenty of motivation for Mr. Monatis, in addition to the other things that I've mentioned, to get it on the straight and narrow this time.
Okay. Have you all had a chance to discuss anything outside of the bond meeting? Is there a recommendation? I seem to remember the new DWI and was a breath test, so I think that's why we got it so quickly. Have you all had a chance to discuss that?
No, ma'am.
No. Ms. King, can you confirm, you said fourth, and I think that's what the report indicated. We don't have any other like New Mexico DWI, or is this a true fourth?
Yes, Your Honor.
Yeah.
I can check one more time.
Ms. Spinella, just because this is on the probation case for sure, any update? I know there was a summary. Any input from probation on this?
Your Honor, the only thing that's outstanding is from the time being on probation, he has not completed the DWI repeat offender class. And the rearrest. I mean, those are basically the highlights of it. There had been issues with the device, which I believe they had already been addressed in the past.
Was he allowed to drive on that probation case?
No, Judge.
So he was driving. Yeah, that's part of.
Your Honor, I pull up the rap sheet and he does not. This is the only 4 DWIs that we have.
True fourth. So, okay, let's go back to the bond. I'm not really sure, other than the treatment, his efforts at treatment, that much has changed since our last bond hearing. So for now, his bond is going to be on the 2016 case. It's going to be 75,000 split, 50,000 cash surety, 25,000 PR. He may not operate a motor vehicle, period. Standard DWI, third conditions. So did he have a monitor, Carla, or he never had the monitor, or he just wasn't? How was it before? What was going on before?
He did have, Judge, the Smart Start and home mobile device. That's what he had.
Okay, so he's going to have the portable monitoring unit with the GPS, daily reporting requirements, and then all the other standard conditions. We're going to come back in 2 weeks on another, well, what's our next setting, Chris? To get to the case.
About 2 weeks, Your Honor, the 27th.
It is? Okay. So we're coming back on that date. If he bonds out, then he is to appear on the Zoom.
We actually don't have any dates, upcoming dates on the 2016 case, Judge.
Okay, so it's going to track the new case. Let me find it.
I arranged that one. I believe the next one would be the 20th.
So I have, I'm showing January 27th.
Oh, yes, ma'am. That's correct. On the new case, the 2021, yes, the next hearing is Judge's Conference 27th, correct.
So let's add the 2016 case to that. Chris, we need to back it up with a 3 p.m. setting in the event that he is still in custody, okay?
You got it, Judge.
But if he's not, Mr. Roman, then he needs to appear on Zoom, okay? So let him know all the details of doing that.
Yes, ma'am. Your Honor, just quickly, would you repeat the bond conditions again, which you've
So, yeah, it's going to be standard DWI third, which means that he has to have the portable monitoring device that has daily reporting and GPS capabilities. He may not operate a motor vehicle. Basically, these are going to mirror very much the conditions he was on before. Report weekly, subject to urine and breath analysis, curfew 10 p.m. to 6 a.m. unless he is working or going to school. Subject to use no illegal drug or alcohol. We can add to that, attach to it any of the conditions of his probation in 20, all conditions of probation in that case.
Okay, how about the act? You repeat the bond?
Angie, you're stopping all bond.
So I think I said 75,000 split, 50 cash surety, 25 PR.
Very well. Okay, Your Honor.
All right, so we'll see you in 2 weeks. Mándeme.
Just to remind the court that his actual probation case did expire on 11/21/21.
Oh, he already expired?
Yes, Judge. The MTR was filed prior to the expiration.
Oh, well, wait a minute. Well, okay. All right, I didn't realize that. Well, the bond is going to stay as it is.
Okay, thank you.
Alrighty, thank you. All right, okay. Mr. Nunez, are you here on Annex? If I could have, is it Cristobal Carrillo?
Correct.
Okay. Mr. Carrillo, okay, go ahead. I gotta go ahead, sorry. Calling cause number 2021-0D01748, State of Texas versus Cristobal Carrillo. May have announcements, please.
Roa King for the state of Texas.
Leonel Nunez on behalf of Mr. Cristobal Carrillo.
And Mr. Carrillo is appearing from the jail annex. Mr. Nunez, we are scheduled for a bond hearing. You may proceed.
Thank you, Your Honor. Your Honor, our client's been in jail since June 9, 2021. He is 23 years old. He has a wife here in El Paso. He also has a 1-year-old with her, and they just had a newborn a couple of months ago. At the time of his arrest, he was the sole provider of his family. He was currently working at gatekeeping Transmitarian, and he has informed us that he will still have a job if he is to be let out. Being that he was a sole provider for his family and that he has a 1-year-old and a newborn, it would be very beneficial for him to be able to get out and help his family out. The day that these accusations did come out, he did make immediate arrangements to not only move out of the house and go live with his brother, but he also did go out of his way to come hire us to be able to, clear his name, Your Honor. He would reside at 528 Luna Azul Drive. That's the address that he was staying with his brother. I don't believe he's a danger to the community, Your Honor. He has no criminal history prior to this last arrest. He does understand the severity of the allegations against him at this time, Your Honor, but he does want to go to trial. And this is a case that we're going to have to try if it doesn't get dismissed by the state. His children are here. The love of his life is here. He wants to be able to provide for them. So I don't think he's also a flight risk. We are humbly requesting a full PR bond, Your Honor, but if the court is not willing to entertain the full PR bond, we are requesting a bond reduction to at least in the range of 30 to 40,000, Your Honor. And I think it's currently being set at 100,000 at this time.
100. All righty, Ms. King.
Your Honor, bond was, we had a bond hearing on December 14 that was denied. And as well, this is an 8-count sexual assault of a child. The state is opposed to a reduction of the bond.
What has changed, Mr. Nunez, since our last, other than time passing, what has changed since our last bond hearing?
We did have a bond hearing last time, Your Honor, but we did want to go in front of you. I believe we went in front of an associate judge at that time, Your Honor, because you were in trial, which is why we did request another bond hearing to be able to present you with the new facts, which would be that he does have a newborn child. I think that changes his circumstances, and I think it, lowers the risk of him being a flight risk as well, Your Honor. He wants to be able to get out and provide for his family.
Yeah. Unfortunately, due to the nature of the allegations, the safety of the community, the request is going to be denied. The bond is going to remain the same. We have a trial setting on, let me see.
It's March 18th.
March 18th. We need to add to that, Chris. So Mr. Nunez, we do have the panels, 4 panels available for jury selection, but that would mean starting, and I know Mr. Benjamin, we had discussed these dates before. If he's got issues with them, I know he'll let us know, but I just need to make sure you all are aware. We need to add the 17th because we would actually be starting on the 17th with those jury panels, so we could have as many as we can. That would mean 4 panels. We also need to add backup dates of April 7th and 8th and May 19th and 20th. Those are the dates that I have for multiple panels. Okay, so if you need to come back, we'll do that. Where are we? What is the rec on this case?
Your Honor, the state does not have a rec yet because I am still in the process of speaking to the complaining witness.
Okay, we're coming back on February 17th. That's a whole month. So we need to know by then what the offer is.
Yes, Your Honor.
Thank you very much.
Yeah.
Thank you, Mr. Carrillo. Thank you, Mr. Nunez. Annex, if I could have, let me go back to the end. It's going to be Mr. Darnell's client, Mr. Valles, please. Sorry, Mr. Darnell, I'm a terrible bailiff.
That's okay, Judge. You've got other fine qualities.
Mr. Valles, is that you? Yes. Let's go ahead and get started. Calling cause number 2019-0D04292, State of Texas versus Daniel Valles. May I have announcements, please?
Roa King for the State of Texas.
Jim Darnell for Daniel Valles.
Okay, now I believe I set this for a status because we had a hearing right before the end of the year. I believe Mr. Ferguson was here. And yes. I had kind of given you all a heads up. Let me see, backup jury trial. Okay, all right. So I have us down for, I think we've gone past one date. Have you all made any headway on this one? Are we still looking at a trial or are we looking at something else?
Judge, since our hearing the end of December, I have spoken with Curtis Cox 3 or 4 times and with Scott 2 or 3 times. I think we're going to get this resolved, but I think we're going to need some more time to do it.
So I have us down. So do we have a new offer or are we still just working on things?
We're working on things.
Okay, so I have
sort of running messages back and forth to the boss.
Your Honor, and also there is 2 witness statements that actually needs to also be translated. They are in Spanish, and so I have that submitted as well.
Oh, I didn't know about those.
I discovered that this morning while going through the binder.
Okay, so we have actually our final hearing plea deadline February 8th. Based on that backup trial setting of February 11th, because we're going to need multiple panels, we will be starting on February 9th. I can get 4 panels. I have 4 panels. It just means we back up a little bit in terms of the dates. So we're going to keep those. Chris, we need to make sure we have it started on February 9th, 10th, because that's when we have the panels.
You got it, Judge.
We're going to have a backup date of March 17th and 18th. Again, those are my dates when I have those multiple panels. But I think, we're already at backup. I mean, obviously, if we have statements out there that still haven't been turned over, Mr. Darnell, if you need to file something, let's have it filed and heard before that final hearing plea deadline. Okay,
Yes, ma'am.
thank you very much. I don't know what else is outstanding. What else is outstanding? Any new surprises, Ms. Key?
No, Your Honor. So those statements are on portal, but they are in Spanish. So
Okay, got it. Got it. They just haven't been translated. Okay,
that's correct.
all righty. Oh, yeah. I don't want to come back. No, we're just going to come to the final hearing plea deadline. If you all need something before then, let us know.
I will.
Thank you very much. Thank you, Mr. Baez. All
Thank
right,
you.
so then, thank you, Mr. Darnell, you're excused. Let's get Saul Santana, if Mr. Yanez is here.
I'm here, Judge.
Okay. This is a probation case.
It is.
Okay, let me see if I have a summary. I do. Mr. Santana, is that you?
Yes, ma'am.
Okay, bear with me just 1 second and I'll call the case. All righty, okay. Calling cause number 2016-0D00317, State of Texas versus Saul Santana. May I have announcements, please?
Raul King for the
Please, Judge, on behalf of Mr. Santana, Your Honor, we're ready.
And we are scheduled for a bond hearing. Mr. Santana is appearing from the jail annex. Mr. Yanez, you may proceed.
Yes, Your Honor. My client has been incarcerated since the second day of December 2021. He turned himself in. Apparently, there's his probation officer was telling him he didn't report for 2 months. I believe it was August of 2021 and September of 2021. He did call. I do have a voluminous amount of records, phone records, Your Honor, that he did make attempts to call, and for whatever reason, they were not noted, and that's why he's there. My client is a 37-year-old U.S. citizen, Judge. He's been living at 15265 Cactus Flower 79938 with his mother-in-law, his wife, and his 2 children who are 9 and 6 years old. He has been on probation since September 2016. There is a motion to revoke filed that was filed on the 31st of August of 2021, so the last day of his probation. He is a electrician. He does have a job at Code Electric. He makes $18 an hour. He does have one prior violation that he got some time in county jail for a long time ago, Judge, and he will tell you that he did comply this time, and that if you do put a bond on, he will comply with all the terms. I believe aside from that, he's only missing his anger management course in order to complete his term of probation, Judge. So he's on deferred. So we would ask for a PR bond, Judge, or the alternative of $5,000 corporate surety bond, so that he can bond out. We can get the records to the prosecutor. I don't have the motion to revoke. I'm not allowed to see it on the DA portal for whatever reason. But I'll be happy to get those records that I do have to the prosecutor.
What's the, Mr. Yanez, what's the kind of crux of the contacts? Was probation, he was contacting probation, they were just not responsive? I mean, what happened? Because it's about
So what happens during COVID is the defendants call Judge and they leave a voice message. This is not the first time that a defendant is not getting the credit for calling that I've been involved with.
Was there any transition, Ms. Pineda? Were they transition? Was the PO changing? I mean, why?
No, Your Honor, what I see, it's been this Officer Mendoza. The only time he was with a different officer was in the time during the time where he was attending TAP. Officer Mendoza had emailed you back in August to submit an extension because his case did expire already on September 12th, 2021. He had emailed you an extension regarding what he needed to complete anger management since he hadn't done so. There's fees, outstanding fees, and a hearing was to be set. So the hearing was on, let me give you the exact date, on 8/24/21. That's when the date of the hearing was scheduled, and Mr. Santana didn't appear, and that's when the bench warrant was issued, following the VN with the motion to adjudicate to get filed. And from then on, I don't see that there was any contact with probation after that.
So ultimately, okay, so he expired back in August. I mean, the recommendation here is a 1-year extension.
He expired September, Judge.
September.
And Judge, I think it's a little severe for this. I think he's complied. He did tell me that he did change employments around the time, and that if they called him, he couldn't have picked up the phone because he was working, but he was not notified through any other means about his court, Judge.
Okay.
Your Honor, if I may, this is not the first time he doesn't show up. I mean, one of the allegations that the state has put in the MTA is that he failed to report to community supervision. And that was a couple of months, more than 1 month. So we do have this occurrence of not showing up.
This time I can prove that he did a call.
Okay, so he's in terms of the bond, Mr. Yanez, he's local, right? He's not traveling anywhere for work or anything like that?
No, Your Honor, he's local.
Okay. So for my purposes, I'm going to go ahead and grant the request for a PR bond, the conditions of which will be to comply, obviously, with the terms and conditions of probation. What I want to do is have a review hearing on this case in 30 days. If you have something, Mr. Yanez, that you can circulate to probation, basically, I want to see what that is. I don't think a 1-year extension is unreasonable, but if what you're saying is accurate, Mr. Yanez, I'll reconsider that.
Yes,
Okay?
sir.
You know, because we extend him, you know, it's going to depend on him, whether he'll comply or not. And then based on that, you know, maybe it's a year, maybe it's not that long. But, you know, we kind of have conflicting stories here. I'm not sure if it's one, the other, or a mix. So let's see where we are in 30 days.
Yes,
Okay?
sir.
Your client will be required to appear via Zoom at that hearing. And then we'll see if we can all get on the same page. We'll see.
Thank you, Your Honor. Can you please contact us, Saul, when you get out?
Monday. Who was talking?
It was me.
That was me,
Just
Judge. I was asking my client to call me when he gets out, so we don't.
Right. I think Carla was talking. Go ahead.
So, and just to remind the court, and I guess for further clarification, back in 2018, there were some issues addressed with the court about Mr. Sana leaving El Paso and not getting the permission and all that. So there was an MTA filed at that time. It was dismissed. I can have Ms. Mendoza present for the next hearing, Judge. That way, I mean, there's documentation where she's calling, leaving messages, emailing him. So that way everything's clarified.
Yeah, I mean, ultimately, maybe it's a rebel. Ultimately, maybe it's a rebel. I always I don't hesitate, but 2018 is a little before my time. So I'd be a little bit better if I had more concrete information, which I think, you know, if we have her here, that'll be good. And Mr. Yanez can present to the court some issues. I mean, really, if your client's the problem, then we're going down Revo track. Okay, Mr. Yanez?
Yes, Your Honor.
All right. Thank
Your
you.
Honor, I have a question.
Who's that? Yes.
Your clerk.
Yes.
For the PR bond amount, what is it going to be?
Oh, we'll do 25,000.
Okay, thank you.
Thank you. Sorry. We'd like to cancel the probation status set for the 13th. Actually, okay. Probation status set for the 13th. We'll use that date. if we already have a hearing set, yeah, we'll use that date. Whoever sent me that message, thank you very much.
Your Honor, that was actually me, but that's 13th in 2 days. So do you?
Oh, the 13th of January. No. I thought it was the 13th of February.
No, he already has future dates. He has the 13th of this month, the
Okay.
3rd of next month, and the 22nd of next month also.
Okay, I see what you're saying, and now I'm looking at Odyssey. So let's go back. In terms of the scheduling, what we're doing, Mr. Yanez, is we're canceling 2 days from now, and we're going to we'll go to the February 3rd setting, so we don't mess with the calendar anymore.
Thank you, Your Honor.
Okay, so please
Judge,
set up with your
before
time.
we move on, may I say something
Yes.
that I just noticed at the very end of the summary?
¿Qué pasó?
There is a hold out of Kennedy County, Texas.
Oh.
So just. to
Also,
let
he's
it-
not going anywhere. Well, they might, well. We're gonna leave it like that. We'll come back on the February date. You're right. So will they come and pick him up if he's out on?
I
like, if
don't,
he-
I don't know, to be honest, Judge. I don't know.
Your Honor, I'm checking to see if they've placed a hold for extradition. Just a moment, please.
Thank you, Martha.
Yeah, it's on the previous section on that court summary. No, Mr. Santana has a hold for Kennedy County. What's that for?
I believe it's another charge, though, an old charge, Judge.
Your Honor, it does say that they will extradite. It's for possession of a controlled substance.
Marijuana, Judge.
I'm not sure of the substance, Your Honor. It just says possession CS. So.
Oh, okay. Mr. Yanez.
Yes, Your Honor. I am aware of that. It's a marijuana oil or THC oil charge. That's an old charge, Judge.
Do we know a date of offense on that? Do we see like the hit, the FFJ hit? Let me see if I can see
I
it.
think this officer is supervising that one. Let me double check, Judge. Sorry, it wasn't mentioned on my summary, but let me double check. I apologize. Odyssey is just very slow today.
Yeah, it is slow today. No worries. We only have a few more. Let me see. Hearings, jailings, booking. Detainer.
So Judge, on that case, he got probation out of that county. It's a 10-year deferred case. So technically it's from 7/30/19 through 7/29/29.
So he picked up a new case while he's on probation. Did we know about, we did know about it, Carla?
Let me double check if that's the reason why there was an MTR filed and when he was leaving El Paso County, maybe that had to do with what happened in 2018.
Mhm. $400 to $400.
Your Honor, the NPA that was filed in 2018, May 21st, it was just for failing to pay community service hours or perform service hour, I apologize, TAP, anger management, and failing to report same allegations as the last MTA.
So this drug charge just kind of happened over here and not probation. You don't reflect anything, Carla?
It's loading. I am so sorry. It's still
Oh.
thinking to.
So he pled over there while he was on probation over here. I mean, I think this is kind of, yeah. Do we show, let me see on that. Do we show a date of offense? I mean, it's got to be 2019 something, right?
There's no date of offense on it, Judge.
No. Let's see, there's the hit. No, probation violation. Act assault. Data warrant. 8/30/2021. Okay, that's ours. And then where is it? Full extradition. Conditional release violation. Data warrant is 10/19/2021.
Judge, I don't see that as far as probation that it was I guess,
Being tracked in any way, like
looked
we
at
never,
as a
the court
rearrest.
never considered it.
Yeah. I will ask.
Well, Mr. Yanez, this kind of changes things. I mean, maybe, does that arrest, is it any way consistent with his failures to report?
The date of offense, Judge, I'm sorry, on that one is 1/11/19.
Is that when we have him? I need to go back to the summary. Is that when we have him MIA or? Yeah, this doesn't look good. So I'm going to take that back. He's not getting a straight PR bond. His bond is going to be $50,000 cash surety. And the 13th is canceled. Mr. Yanez, we'll see you at the next setting.
Yes, ma'am.
All righty.
Thank you.
All right, thank you. Okay, that got messy. Let's see. So do we have Kevin Gomez?
Yes,
Mr. Carmona, are you there?
Your Honor, I just started a stipulation in juvenile
Okay,
court.
Go back.
Can I come back?
Yeah, no, I'm sorry.
Thank you.
Yes, you can, Omar. Annex, I'm sorry if we could have Ibargüen, if I'm saying that right.
Ibargüen Hugo? Yes, ma'am, he's coming right up.
Thank you. Okay, so on the previous case, on Mr. Santana, basically, we never knew that he got that 2019 drug case, right? That's kind of how that, I'm hearing this now.
Judge, and the failing to report actually did fall in between.
Yeah, he didn't report and he just stayed quiet about the time because he was like, uh-oh. And now he's messed up over there because he's just floating around in two different worlds. All right, Hugo, is that you?
Yes, ma'am. Yes, Your
All
Honor.
right, let's go ahead and get started. Calling cause number 2021-0D0-2479, State of Texas versus Hugo Ibargüen Jr. May I have announcements, please?
Roa-King for the state of Texas.
Leah Martin on behalf of Mr. Ibargüen.
And the defendant is appearing from the jail annex. We're set for a bond hearing. Ms. Martin, you may proceed.
Your Honor, my client has two bonds and they're both set at $5,000. They arose from the same incident. He has a state jail felony pending in your court, and he also has a terroristic threat that is a misdemeanor class B that's pending in a misdemeanor court. My client tells me that he would reside with his mother at 8342 Lynn Haven. He has worked in the past and has advised me he would go to one of the employment agencies in town and see if he could get hired doing whatever he is competent to do. He has told me that in the past he has done odd jobs to include electrical, sheetrock, handyman work, Your Honor. He cannot afford any of these bonds. He's requesting straight PR bond, Your Honor. He does have mental health issues. I did advise him that he needed to talk to Lulu Garcia and set up something with emergent if he is released. He advised me that he would go to emergent to do that, Your Honor. And we have nothing further, Your Honor.
Is he receiving any treatment? I don't need to know the details, but is he receiving any kind of treatment in the jail, Julia?
Yes,
Your Honor, I
yes, ma'am.
asked him.
I am, Your Honor.
Okay, all right. Julia, did you have anything else?
No, Your Honor, nothing further.
Okay, Ms. King, go ahead.
Your Honor, so this is not a first offense for him. So we do have a DWI conviction in 2008. We have an evading arrest that was dismissed in 2008 as well. We have a conviction for theft of property, 2012, possession of marijuana, less than 2 ounces, 2 conviction, 2016 and 2012. And so this is not his first offense, Your Honor.
Okay. And you said it's at 5,000, Julia, it's 5,000 cash surety?
Yes, Your Honor, on this one, and it's also 5,000 cash surety on his misdemeanor, Your Honor.
Okay, so as to this case, I'm going to deny the request based on the criminal history and the circumstances, nature and circumstances of the offense. The bond will remain the same.
Thank you, Your Honor. I believe we said sometime early next month, and perhaps Mrs. King could get us a recommendation on a plea. Thank you.
Thank you, Ms. Martin. Thank you, sir.
Yeah.
Okay, am I missing anybody? I think the last one was Mr. Carmona, so we can just wait on him for a minute. But Chris, if you'll go ahead and take us off of you.